Good afternoon. Good afternoon. Good afternoon. How do? How do? What we're going to talk about today is intrinsic fraud. The intrinsic fraud it goes to the heart of the case as far as the heart of the matter or the heart of the fraud. We're gonna talk about the Labor Relations Department in their actions of filing a writ, or just filing actions to go to 40 rector in reference for disciplinary actions and possible termination. The key thing of it is the officer filed a EEO complaint. In filing said complaint was constitute the complaint was a violation of Civil Service Law, Section 75B. Basically, it was a whistleblower complaint. The whistleblower, once that kicks in under Civil Service Law, you automatically kick in New York's labor law, which is subsection 740 under whistleblowers. And then also along with that comes New York City local law number 33, which is also a whistleblower. So with these three, the primary thing about it is once they're kicked in, once notification has been made, the employer can take no adverse actions. None. Said action to do so would constitute violation of A, the employer's corporate compliance policy, B, because they did it, is about to just say we're going to disregard and not going to follow these laws, what constitutes violation of that Jackie Robinson, I like to call it, number 42, U.S. Code 42, deprivation of a right or privilege. Okay. The key thing is that the labor relations director was like, I don't care, we're going to go ahead with this. We're going to continue on. Okay, so be it. The problem is that once you tell your representing business agent from your union, they're supposed to say, nah, this is deceased right here. But if your union is not representing you properly, they just open the door for breach of contract, and you can take and file a claim against them. But we're going to stay with the Labor Relations Department because how they violated the employer's corporate compliance policy. In doing so, by continuing, okay, with the hearing, they're now violating continue with the hearing. Let's say that will fall under criminal liability of the corporation, which would be subsection 2020. Okay, penal law code. This is basically going to be a Class A misdemeanor. Because she's a director, subsection 2025 of the penal law code under criminal liability, because she's an officer or employee. The mere fact that you are aware, or the officer told you that there's an EEO complaint filed, and you say, well, we're still going forward with it, violate, and then that's showing that you are aware of it and you're working in cohesion with somebody else, because they just pay them no mind, just go ahead. So that would bring about the possibility of Subsection 105.000, which would be conspiracy, penal law code. The fact that you continue with the matter, we're going to go to subsection 19500, which would be official misconduct. You're a public servant. Said actions to continue, like I said, once again, by violating your corporate compliance policy, which is registered with the state. We're going to bring about subsection 19500.05, which would constitute obstruction of governmental administration, because under your corporate compliance policy, you have a policy that for what you're supposed to do and how it's supposed to be run. Now, the mere fact that you submitting a punishable instrument, that would be subsection 21045, class A misdemeanor. Or for the punishable instrument for filing on the record, it's class A misdemeanor. Then we're going to go to the mere fact that you did that. We're just going to go to subsection 17530. No, 35. Offering an instrument for filing on the record with false written statement. Because the punishment instrument the stuff is false. Okay. Along with that, we're going to go to subsection 496.02. That would be corrupting the government. Because you're sending it to other entities, you sent it to 40 record, you file it with 40 record to proceed. You're filing a false document. You want to enter into court. 40 record is a court. It's a civil court. You want to enter into court, knowing that you're violating and you cannot enter into court with dirty hands. That's fraudulent documents. So, because when you enter into court, you enter into equity. So, let's move forward with that. The mere fact that you're doing this shows, because of the filed complaint, shows your actions of violating of the violation that goes down to the intrinsic fraud. You were supposed to stop. How about we say cease and desist? You were supposed to do that, but you didn't do that. You said, I'm going to go ahead and I'm going to send this in, and he's just deal with it. Not a problem. Not a problem. The mere fact that you're representing an attorney, took the document, held the documents. I got the file right here. We're going to file this on the record. It's already filed on the record. And you're turning it in to the judge. You're submitting it to the judge. So you're submitting false documents, right? Yeah. Okay. Violation of New York as an attorney or lawyer or counsel. You're now violating New York's Judicial Code of Conduct, Part 1200. You're now because of the labor relations director, you're now burning the lawyer, your own lawyer. So you're submitting this document, and you got your lawyer submitting it, and they're violating their canons. Why? Because the mere fact that they have it, it constitutes the appearance of an impropriety. Under Canons 9, or let's say it right, Lawyers Code of Professionalism and Responsibility, Canons 9, Lawyers are to avoid improprieties and even the appearance of impropriety. So they didn't avoid it, and they went ahead with it. Said actions to do that would violate New York's judicial code of conduct for attorneys and lawyers. And we're going to go to 3.3. That would be their conduct within the tribunal. So they got in court. We had the court. So your conduct within the tribunal, you were supposed to be trustworthy. You were supposed to be honest. And you're supposed to be impartial. Your said actions violated that. Let's move forward. Also in judicial code of conduct, we're going to, part 1200, we're going to go to 4.1, which still says you have to be trustworthy. Yes, you got to be honest and impartial. You violated that. Then we're going to go all the way up. Let's go to 8.4. 8.4 is misconduct by an attorney or lawyer or counsel, which still says the same thing. You got to be honest. You got to be trustworthy. You have to be impartial. But there's another part that says about being deceitful. Said actions to do all of that. A violation of your New York State Judicial Code of Conduct brings about a cause for go to 8.5. File a complaint with the Judicial Committee. Okay. So when you look up intrinsic fraud and go to the heart of the matter, you will learn that the heart of the matter was the initial complaint from the officer. That was the heart of the matter. And then how they try to cover it up. We're just going to cover it up. Nobody know. It's been documented. How? The officer went to supervision. As per the employer's corporate compliance policy, says how to report a compliance issue. Speak to your supervisor or speak to a member of management. So the officer went and reported the incident to the tour captain and into the morning tour captain. So both captains were notified. Yes. After notifying the captain said you are to go up to the Human Resources Department and you are to file complaint with the facility's EEO official based on the fact that the individual try to deprive you of your right to park in the parking lot, which you were paying for parking for the past 2 years and a month prior to him being hired. And this is a probationary employee who's trying to deprive a person. Are you kidding me? Who violated the corporate compliance policy. What really gets me is, how did he get to stay for 8 years and still kept violating the corporate compliance policy by violating federal, state, and local laws? I don't know. You do the math on that. But in closing, you know the routine. The facts cannot be altered nor denied. You have a wonderful day, and I'm out.